Imagine going to trial with no witnesses, shaky evidence, and everything on the line. Can justice really be decided like this? Stay with me. This courtroom moment will surprise you.
All right, so you're Romeo Johnson.
Yes, ma'am.
And Mr. Johnson's cases are set for trial to begin with jury selection next Monday. Was the announcement?
We're ready, Your Honor. Situated for trial. The judge provided how the court rules on a certain issue, and that issue being we're going forward, if the state decides to go forward on the unlawful possession of firearm by felon. We have literally just two pieces of evidence for that trial, no witness testimony. The evidence, one of the pieces of evidence we want to introduce is a surveillance video that was introduced during the murder trial. The court will recall that this defendant was found not guilty in, and that the surveillance video shows what appears to be the defendant in possession of a firearm. The sponsoring witness of that video is out of the country. It will be out of the country for a month. Under Rule 804 of the Texas Rules of Evidence, I believe the state can use the prior testimony of that sponsoring witness because it was subject to cross-examination by defense counsel. We have secured a transcript of that witness's testimony. We provide a copy of that transcript to Mr. Wilkerson, and we will, if the court will allow us to use that transcript, then there's no need for continuance. We'll be ready to proceed with trial.
Your Honor, I didn't come prepared to argue that this is the first one. I mean, that unavailability, unless Mr. Coleman sent me something yesterday.
I don't see anything. There was I guess, just recently filed a notice of intent to introduce transcribed testimony.
I did file that, Judge, with regard to not only the surveillance video, but also with regard to the defendant's own testimony as well. The court will call you to the stand and essentially admit to possessing a firearm.
Which murder trial was that? Remind me what I'm.
Romeo Johnson murder trial. It was the complaint was the victim was one of the twin brothers, Ronald Barnes.
Yeah. Oh, yeah.
You recall the brother was in the wheelchair that testified on that. With regard to this,
Give me just a second.
Ronald McDonald.
Yeah.
And Judge, I know you're reading, but Mr. Freeze or Judge Freeze did tell me to let you know we're in a 2-day trial.
No. Take me just a second.
Yes, Your Honor.
I don't know that this would.
My interpretation.
I mean, under 5, so 804A5.
804B, I think is what
Well, first is A is the criteria for being unavailable. So a declarant's considered to be unavailable if. So you've got to get one of those 5 to be unavailable. Then you go to B. So it's not 1, 2, 3, or 4. So 5 would be the only one possibly. It states that the is absent from the trial or hearing, and the statement's proponent has not been able by process or other reasonable means to procure the declarant's attendance or testimony.
That is what we're hanging our hat on here. My investigator, Mr. Bass, is here to testify on the efforts that the state has endeavored in to secure the presence of the sponsor.
Okay.
And I represent to the court that we've been unable, despite our best efforts, to secure the presence of evidence, given the fact that he's out of the country.
And so, all right. So if we're going to get into that, we'll wait and do it at another time. I'll either lunch or like tomorrow morning or something.
Yes.
Because I need to set. This is probably. We're down to maybe 2 cases, so I will need to make that decision in a number of the cases. So let's do this, because I would need to hear that information. I think I want to look up a little case law just to make sure. And so you've got one witness
No witness at all, just.
No,
claim
one
to
witness that's unavailable,
Yes.
and that witness would be
Sponsor.
sponsor.
The surveillance video that purportedly shows the defendant possessing the firearm.
And then the,
And the other piece of evidence will be the defendant's own testimony. For planning purposes, Judge, I suspect this trial, at least the state's portion of the trial.
I just feel like without reading that, and I've never had this come up, where in his own trial, introducing testimony seems to violate the Fifth Amendment to me.
I don't follow this.
Well, I mean, it's almost like you're forcing him to testify by putting on prior. I don't know. Let me look into that.
Statement by a party opponent, Judge. I mean, he's admitted from the stand under.
I just need to do some research that if it's I know if it's another party potentially, it talks about when it's a criminal case, what's given as a witness at a trial or hearing of the current or a different proceeding and is now offered against a party.
I mean, he very well could have asserted his Fifth Amendment right during that trial, and he did not, Judge.
Okay, let me look into that. You look into that as well. So
Yes.
804, it looks like we've got two things. One is under A with regard to the unavailable
Yes, sir.
witness. The other is under B, which is the former testimony of your client. So let's, I'll give you an opportunity. About how long do you think you guys will be going?
We anticipate finishing this afternoon, Judge. I could come back on the lunch break, or
No. You're in the middle of a trial. I don't want you to have to think about this and do that. I will number the cases tomorrow morning. So let's take care of this. Are you available to come? It won't take long. That gives me some time this afternoon to also do a little research.
I've got another case in the 317th, oddly enough, but I think I can kind of delay that.
If you can come here first,
Yes, Your Honor.
it won't take us longer than, it'll take 15 minutes. I mean, there's really, I'm assuming your investigator, it will be quick to testimony as to the unavailability. The other is just legal issues that we all need to just look
I'll
into.
ask for a trade out since I couldn't
Perfect.
stay here today.
All right. So head back down there. We'll get you back over here tomorrow morning, 9 o'clock.
All right. Thank
Okay,
you, Judge.
sounds good. If everybody gets here a little early, we can start early. I'll try to be here early as well. All right, go back with the bailiff. We'll see you tomorrow. Yes, sir. You'll come back tomorrow, and that way we know what's going on for sure if you're going to trial or not. Yes, sir. Good morning. Are you Derek Green? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
It looks like we're going on lesser, correct?
Yes, Your Honor.
I'm getting there, sorry. All right, Mr. Green, in cause number 25 DCCR 1119, the state has elected to proceed on count one only, and in that count, to the lesser included offense of a Class B misdemeanor terroristic threat from June 19th of 2025. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Smith? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And are you a U.S. citizen? State tenders number 1.
Okay.
It's admitted. Is there any evidence that Mr. Green is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class B misdemeanor terroristic threat. Sentence you in accordance with your agreement to a term of 150 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff. Thank you. Thanks.
Thank you, Your Honor.
This case proves that one decision in court can change a life forever. If you want more real courtroom stories, legal breakdowns, and shocking moments like this, hit subscribe right now and turn on notifications so you never miss what happens next.